Hello, everyone. Welcome to the NITRUS talk. This is Rahul Vadodkar from 1985 batch. This today's talk is about estate planning, mostly wills and trusts. So we have an excellent couple of speakers, Donald Quirke and Jeffrey Greener. So with that, let me also add that this is not a professional advice. This is for information purpose only. If anybody wants to take next steps, I would encourage them to talk to the speakers or anybody else, any professional. With that, let me introduce Donald. Please go ahead.
All right. Hello, everybody. Thank you for the invite, Raul. I appreciate it. My name is Donald Quirke. I'm an independent insurance financial planner based in New York. I've been in the business since 1991. Over the years, I've received many awards for leadership as well as for production and that sort of a thing. So, we're here today to talk about wills and trusts and general estate planning. So with that, I've worked with Jeffrey Greener several times over the years. I've known him for a very long time. He's an attorney also based in New York. He's a partner with Rivkin Radler. And I'm probably just going to speak at the end of Jeff's presentation just to give an idea of some of the products and services that I specialize in. But primarily, just for the purposes of this part of the segment, it's life insurance, disability income insurance, long-term care, and annuities, which would include 401k and IRA rollovers. So with that, I'm going to hand it off to Jeff, and I'm going to let Jeff, take it from here.
Well, thanks, Don. Thanks, everybody, for having me. I'm the kind of person you wind me up, and I'll just talk forever. So just pull the cord or have me stop when you want, and I'll answer any questions you have. So as Don said, I'm an estate planning attorney, tax and estate planning. We joke around as sort of cradle to grave and beyond, all the needs that a family, business owner, professional might need to help plan their estate, deal with estate administration, guardianship, elder law, special needs planning, and asset protection. All of those are encompassed in the estate planning field. And as we get older, there's more and more elder law. That's a component of trusts and estates, basically. So what I want to talk to you today is about estate planning essentials. Really, what you need to get started, what you need, hopefully, to motivate you to create your own estate plan, or if you already have an estate plan, review that plan to make sure it's up to date to meet the needs of your family. So basically, what is estate planning? It's really, preserving, protecting, and passing on your wealth. You want to leave your assets in the most tax efficient way possible, in a way that benefits your family, in a way that protects them from themselves and or from others. Additionally, preserving your independence and dignity as we age. So there are documents and there are planning tools that we put in place now while we're healthy and have all of our faculties to make sure that, the remainder of our lives, that we get the most quality out of our life. So sort of good news, bad news. You're all likely to live a very long time, whether you like it or not. And actuarially, the longer you live, the longer you're likely to live. So you really have to plan now for, the next phase. From in financial planners, most people, when they talk about doing their estate plan or their financial plan, they're talking about, the accumulation phase, building wealth, saving wealth, but they don't think so much about distributing wealth. And that's really where an estate and tax attorney like myself come in. So what a plan does, it lets you direct who gets assets, how they get assets, and when they get assets. And all this is done in a series of written documents like wills and trusts and healthcare proxies, which I'll talk about a little more detail. If you don't make your plan, the state where you live will make one for you. When you die without a will or a trust, it's called dying intestate. And your state, New York, New Jersey, Connecticut, California, they have a plan of distribution if you don't make one for yourself. And it's not usually what you want. You don't get to determine who the guardians for your children are. You don't get to determine how assets are divided between a spouse and your children. So making a plan, reviewing that plan is really an important part of your overall financial plan. It'll give you a more secure financial future. It allows you to leave more to your heirs, and basically gives you greater peace of mind. I like to say it lets you sleep at night. I want to create a plan for my clients that lets them sleep at night. Everybody's considerations, everybody's key issues are a little bit different. So it has to be customized to meet your particular needs. So let's talk about estate tax. First of all, spouses can leave unlimited amounts to one another during lifetime and at death. There's never any tax from one spouse to another. But the government, I like to say the government's dumb, but it's not stupid. They will collect their money at some point. So if you're the last spouse or you're single, the federal estate tax exemption is $13.61 million. That number is good until the end of 2025. Under the current law, that is supposed to sunset and drop in half on January 1, 2026. So, everybody's actively looking to see, what's going to happen with the election. No one really wants to know. So for those larger estates, we're advising clients to consider gifting now and using up some or all of their exemption while they still have it. If you have assets in excess of that threshold, you pay 40% of the excess to the federal government as an estate tax. Okay? New York and about 10 other states have their own estate tax. Usually they're more generous than the federal exemption, but there's money to be paid to your state. In addition to that lifetime exemption that you could use during your lifetime, and whatever you haven't used during your life, you can use at death, you can give $18,000 away to as many people as you want each and every year. That's called the annual gift tax exemption. You always have that. They've never taken that away. It grows with inflation. And over time, it could really be beneficial by giving, $18,000 or $36,000 per couple. You can get a lot of money out of your estate that way. So what is your estate? It's all the assets that you own or have an interest in. That's your taxable estate. The government just wants a snapshot of the value of your assets at the date of death. They really don't care the nature of those assets. They want a dollar value. Okay? A lot of people ask me about joint accounts. I added my child on a joint account. The presumption is that it's your money. It's the senior owner's money. Again, government may be dumb, but they're not stupid. The presumption is it belongs to the parent or the grandparent, and it's all their money unless the child or junior family member can prove that they funded those accounts. So adding kids' names onto accounts is not necessarily the best way to plan for a couple of reasons. So now, when we pass, how do our assets go to our loved ones? Well, if we have a will, they pass through probate. Your will is just a written direction of how assets go after you're gone. They can go by operation of law. That covers joint tenancy or rights of survivorship. So I may have purchased my home with my wife or my husband, and we own it together as joint tenants. Then my house passes automatically to my spouse. I can create a trust. I put assets in the trust. The trust then directs where those assets go. Again, I can own them jointly with another person. I can have a beneficiary designation, like on a 401k or insurance policy. I may name a beneficiary. Those people get those assets directly. And then there's intestacy. If I have no will the government makes one for me. Now be careful. A lot of people will add a child onto an account for convenience when they really want the assets to be divided 50-50 when they're gone. And I've had numerous cases, that account that has your child named as a co-owner or as a beneficiary goes entirely to that child. And they don't always want to share with their brothers and sisters. They feel, hey, I've been taking care of mom and dad for all this time. You moved to California to find yourself. I'm here doing all the work. Mom wanted me to have that money. So be very careful when it comes to adding kids onto the accounts and letting everybody know what your ultimate goal is. So assets can pass in any one of those ways. And just because you have a will or a trust that says my assets go 50-50 to, John and Jane, if one of them is named on an account as a beneficiary designation or as a co-owner, they get 100% of that, and your will goes right out the window. So be careful. Okay. What are the essential planning documents? Well, a will is the most common form of document to pass your assets down. Still works very well. But when you have a will, you have to go through probate. Probate is the court validation of your will and the appointment of an executor who collects values and then transfers all your assets. Especially since the pandemic, we found that the courts are backed up. Courts everywhere are backed up, and people don't want to deal with the delay of waiting for the court to approve a will, or they want privacy. Therefore, a lot of people are migrating to revocable or living trusts. Revocable trusts are merely will substitutes. They direct the way your assets go, just like your will did. But if I retitle my assets into the name of my revocable trust while I'm alive, I skip probate after I'm gone, I ease administration, I lower fees, and I lessen my aggravation factor. So revocable trusts are really where it's at. They don't give you any more creditor protection or asset protection than a will. Don't be mistaken. If I have a revocable trust and I have access to all my assets, potential creditors have access to. So these are not Medicaid planning devices. They're not asset protection devices. They're really will substitutes, especially if I have property in more than one state. Now I can avoid property in 2 states if I retitle my assets into my revocable trust. I have total control over those assets. I keep all my real estate exemptions. There's no separate tax ID. My income tax return stays the same. The basis of all my assets stay the same. So revocable living trusts are really the way to go on a going forward basis. The next set of important documents are advance directives, powers of attorney. If I'm alive but unwell, I want to be able to designate someone to act for me. A power of attorney lets me do that, either immediately or upon the happening of my incapacity. A living will healthcare proxy, the other key document, designates someone to make end-of-life decisions for me if I can't make them for myself. Otherwise, the hospital is going to keep you alive as long as they can. Not everybody wants that. They want to designate someone to do that. And sometimes they want to designate what they want. Pull the plug. Don't keep me going. I don't want to be a burden on people. And other people say, only God can take me away. Keep me hooked up till there's a miracle. But by putting it on paper, everybody now knows your wishes, and they can follow those. And the hospital will follow those. And remember, all of these documents can be amended or revoked at any time that you have capacity. So while these things are meant to stay in place until your last breath, you can modify them over and over again. Beneficiary designations. Take a look on your employer sponsored insurance and 401ks. I have people who, they got out of college, they named their mother as their beneficiary on their 401k. 30 years later, they're married, they have 3 kids, and they never changed the designation. Well, guess who inherits that money? Your mother, not your spouse. So check your beneficiary designations regularly. Organ donation. Some people want to be organ donors. You could put that on your driver's license. You could build that into your healthcare proxy. HIPAA declaration. You all probably know that medical records are private. You can't find out, you can't talk to a doctor about your kids. You can't even find out your kids' grades, right? If you're paying for your kids' college tuition, but you have no authority to talk to them. That's why I tell all my clients, have your adult kids appoint you as power of attorney and as healthcare proxy. So a HIPAA declaration lets people you designate speak to your medical providers about your care. These are all part of your estate plan, But if you're still not convinced, here's what I hear, the objections to doing my estate plan. Oh, I did it years ago. I don't need to do it anymore. A will or trust is not like milk. It doesn't spoil, but your events in your life change. People come into your life, people go out of your life. You really need to periodically review your plan to see that the disposition of your assets is going the way you want it, and that the people you've put in charge are the same people whom you want. I love my kids, but maybe I don't like my daughter-in-law or my son-in-law, or I think this one spends too much money, or I have this concern or that concern. You want to update things once in a while. My family gets along great. There's going to be no problem after I'm gone. If your kids don't see eye to eye now, they're unlikely to see eye to eye in the future. While mom and dad are alive, you could pretty much hold the family unit together. But you've got to be careful. Also, some people need protecting from themselves. They're not mature enough, or they don't have the financial acumen to manage their own money. Maybe money should be kept in trust for them. Some people must be protected from others. Creditors, predators, you never know. A lot of people say, I'm young, I'll get to this when I'm 75. I'll get to this when I'm 85. Not everybody gets there. I wish everybody a very long and healthy life. But as you hear from these celebrities who die too soon, everybody thinks they'll get to it, and not everybody does. And then you've really caused a nightmare for your family. This is what I hear all the time. I'm just a simple person. I want a simple will. Life today is very complicated. Very few of us are that simple. Even with a first marriage and two, well-adjusted adult kids, they take care of their parents. They have other obligations. Don't be penny wise and pound foolish by getting Susie Ormond's $35 estate plan. You won't know if it works until after you're gone. There's no way to test that. I would be very careful about using somebody else's form document or assuming that one size fits all. It really does not. You really want a plan that's tailored to your particular items, and lastly, as I mentioned when I started, everyone has an estate plan, your own plan or the government's plan. And because we don't know how long we're going to live, we don't have a crystal ball as to determine when your time is up. If I knew when people were going to pass away, the line would be out my door, and I can give everybody the personal plan. Another thing, fair is not always equal, and equal is not always fair. We don't always want to leave our assets to our kids in equal shares. One might be very well off financially. One might need more help. One might have special needs. If I leave that child assets, the government may cut off their benefits. So I want to plan for my children differently, And most importantly, if you want your wishes followed, you need to write them down. People have a very selective memory. And I've been in court any numerous times where people will say, well, dad told me this and mom told me that. And the judge will roll their eyes and say, I'm sorry, I can't take your word for it. If it wasn't written down, it doesn't mean anything. So, not only is there a lot of money at stake by planning properly, but there's family cohesion at stake. So, it's really, really important. It's really one of the greatest gifts you can give to your family by creating your plan. Now, I know I rushed through that because I wanted to have time for questions. And Don, you had sent me some questions, which I can work through those particular things. Rahul, did you see those the six items?
Yeah. Actually, one of our members, Sabir, had asked. So I sent him a message today that some of those may be covered right in your talk. And if some of them are not covered, then he can ask here. So after your speech is done and after Don has finished, excuse me, and then we will start the question answer session, and I will give him a chance to ask his questions.
Okay, Don, you tell me. Do you want me to stop now? You want me to go on? What works for you?
Jeff, you're doing great. Keep going.
Yeah, I think if you can give some examples of sometimes when it failed, if people did not do it, especially for mostly simple families, like generally most of us, well, I hope so, that a very simple life, single marriage and couple of kids.
Understood.
Nothing too complicated. So if you can give some examples of where things can go wrong, and if we don't have the trust or will.
Sure. So if I don't make a will or trust, the state will divide things 50% to my spouse and 50% to my children. That's not what most people want. They want 100% to go to their spouse and then to their children. So if you don't put it in your will or your trust, both groups are going to be unhappy. Secondly, your citizenship and your residency are important. The U.S. treats citizens, residents, and non-residents differently when it comes to estate taxation. For citizens and residents, the federal government is very generous. For non-resident aliens, people here on green cards or work visas, not so generous. So your status really matters, really matters. People come, they bring their parents from overseas. That has an effect. People, they send their kids here to college, they live elsewhere. They're not so simple. You really have to plan around residency and citizenship status. Another thing, again, if I don't have a will, the courts name a guardian for your kids until they're 18, and then the kids get their money at 18. Many people don't want their kids getting their money at 18. My kids are 30. I'm not sure they really are mature enough to get their money. I'm glad they're not on this video because they would be insulted. 3 Ivy League kids who I think are the dumbest smart kids I know. So we may want to hold assets in trust for them beyond 18, maybe 25 or 30 or 35, or maybe for their lifetime, because they're in a profession or a career that has a lot of liability. They're a brain surgeon or they're a real estate developer, and they're concerned about lawsuits. Leaving their money in trust would protect their inheritance. So that's another, even for very simple people, just the honey, I love you, here's the money, and then it goes to the kids at 18 may not be the best plan. Some people are in a second marriage. They want to protect their spouse during their spouse's life, but make sure their kids from their first marriage get some money. You've got to have a little bit more sophisticated plan. The big question I get now is probably will versus trust. Will versus revocable trust. I think wills work just fine, but a revocable trust is probably better because you get to avoid probate, and the time and the aggravation is worth it. It may be a little bit more work for you. It may cost a little bit more money for you, but it'll save your kids a lot more. And if I have property in multiple jurisdictions, I have plenty of people who live in New York, New Jersey, Connecticut, and they have a house in Florida. Why probate their will in New York and in Florida? If I create a revocable trust and I retitle my New York house into my trust, no probate there. I retitle my Florida condo, no probate there either. So, that's a real benefit. And if I have, let's say, large assets like life insurance, a life insurance is a big number, the death benefit. We don't really think about it while we're alive, and it's now going to be includable in our estate. If I put that in an irrevocable trust, I can take it off my balance sheet. So that's the difference between revocable and irrevocable. A revocable trust is a will substitute meant to, pass your assets after you're gone, but you have total control while you're alive. An irrevocable trust is a trust into which you put assets to keep them out of your estate, to keep Medicaid away or other creditors away. That's the big distinction. In irrevocable trust, you've got to give up some control over that trust to get certain other benefits. So, all right, I'm going to stop now, and I see some questions coming in, and we can take questions from anyone on the call, or I could answer those. You just tell me, gentlemen, how you want me to proceed.
Yeah. Thank you so much, Jeffrey. This was one of the things that we all keep postponing it. And I actually got it done a couple of years ago when my company provided financial, they said that you can go to any attorney and get it done. We will pay for it. So that's when I actually got my thing done. But before we go ahead, I have some questions. The way we do is I had sent a survey to our people, and those who responded to that, I will give them the opportunity in that order.
Sure.
And once they are done, then I will go to the chat where Subir Banerjee and Chaman Sahu have asked questions. And in that order, we'll give them chance to ask. And then people can raise their hands by clicking the hand icon. And then, but before that, I think Don said he wanted to say something at the end of your talk.
Sure,
so
sure.
Maybe you want to go ahead, Don.
All right, thank you, Raul. I appreciate that. So I was probably thinking maybe I should go ahead with my mini presentation after Jeff is done with his questions, just so that
it
doesn't get kind of mixed up and kind of ruin the flow. So I would think that it's probably best at this point for Jeff to continue with any of the Q&A regarding his material.
Yeah, I think that's a fair statement. So we had Yogesh Tripathi had asked a question. Yogesh, if your question was not answered, you can go ahead and ask.
Yeah, so I had one question, but now I have two. So I will ask two questions. Sorry, Jeff. So first question is, I think most of the participants here are kind of coming from India, and of course, since a lot of kind of property or something we own in India also. So just first question was that the will prepared here in United States are legally admissible in other countries, like example India in courts. Maybe just not to make it very complex, maybe if we know about India, then it will be good, or any generic guidance. And second is that, nowadays I see a lot of ads in TV, especially around willandtrust.com, and I'm sure there are so many. So if there are some websites and they are saying in maybe $100, $200, you just, type in some standard information and they will prepare for you. So whether we should kind of opt for those things, or if not, then like why it is not advisable? These are two questions, Jeff, I had.
Very good questions. So first of all, I have quite a few South Asian clients, and I'm pretty familiar with Indian law. Your U.S. will absolutely be valid there. For clients who have assets in multiple countries, we like to put a recitation in the will or the trust that says that this will cover my assets worldwide, just to give clarity. I have other clients who create an Indian will and an American will and make the distinction. Okay. India is interesting in that they have three forms of wills that are valid. They have sort of the, British common law standard, a Hindu standard, and a Muslim standard. So you can follow the laws according to your custom, or you could just have sort of the generic version. But Indian documents will be valid here, and American documents will be valid there. Okay. Secondly, you get what you pay for. So How much are you going to get for $100? I don't know. And listen, if someone really is a very simple person with very simple needs, it might work for them to go online and prepare it. But they won't know. It's only after they're dead and their heirs take a look at that document will they know if they screwed up big time or they saved a lot of money. So I've seen a lot of these documents, and they don't ask really the necessary questions of most people, because most people are not that simple.
Okay.
Yeah, I think that's great. Thanks for telling about that. Was one of my questions going to be about the foreign assets. So good to know. And also about the online thing. Some it may work for some, it may not. But yeah, I think the next one was Sabir Shakil. He had asked some questions, so I had also sent him a message offline that if any of his questions have been already answered, then he can skip those. But now it is Sabir, your chance to ask questions. You may be mute. Sabir, I think you are mute, so you need to unmute your. Okay, I think we'll come back to Sabir later. Meanwhile, let's go to the chat questions. So first was by Subir Banerjee, sir. Please ask the question. Instead of me reading the chat, and then if you can. Oh, I think he left and he came back, I think.
Hey, Rahul, sir, are you able to hear me?
Sabir, can you hold? I passed on this opportunity to Subirji. So
Okay.
yeah, I'll come back to you definitely.
Okay.
Subir Banerjee, actually, if he's not able to.
I see that question, Rahul. I see that question.
Oh, you do? Okay, yeah, definitely.
Yeah, and that will is fine.
Yeah. Can you read it? So for the recording purpose.
So we're senior citizens, financially okay. One adult son, single, never married, will not get married. He's financially stable, doesn't need help. We have a will that gives us 100% to each other when we pass away. The son gets 100% when both of us are gone. Absolutely fine. So that's a pretty straightforward family unit, and a simple will works.
Excellent. Thank you so much. Now we go to Sabir for his questions.
First of all, thank you for sharing your expertise and knowledge here. We appreciate your time. I think most of the questions have been answered. The only question I have is if we are moving forward with a revocable trust, and if the children are minor, like they are 17 and maybe 16 or below the regular adult age, how would it work, and what do you recommend in terms of if you don't have any local local relative or local someone who we really count on, how to handle that scenario?
Okay, so in New York, for instance, even though you do a revocable trust, you need a will to name guardians for your minor children. So we sort of a simple add-on, and a guardian raises your children until they're 18. You can name guardians anywhere in the world, but a court will want monies to be kept in the United States. So a revocable trust is better because it's not subject to the court's law. What I often do for my clients who have family overseas is we'll do a standby guardian. So we'll create a document now that says, if something happens to us, this person here, our friend, our neighbor, will watch our kids until the more formal appointment of the guardian takes place. So there's no gap in someone raising your kids. So if you have a good estate planning attorney, they will talk to you about that and make sure that gets taken care of.
Okay, my last question would be: do you work with Hayat plans? Do you or Dawn?
We don't participate in Hayat plans.
Okay, thank you.
Okay, thanks, Sabir. And Chaman is the next. So Jeff, if you have read that question, you can answer.
Oh, sure. So I heard some states take everything left behind in the absence of a will or a trust. Is that true? Not really. You hear about this all the time. The states don't really want to take your money. They'll accept the money if they can't find a relative. But if there's a relative out there, that relative gets your money. And there are professionals professional genealogists who search for heirs to connect them to their money. So the government really does not want your money. But if you want to make sure, put it in a will or put it in a trust.
Okay, great. Thank you. Is there another? Okay, so then after these questions, we have people who have raised hands. So anybody has questions, they should raise hand. I can see Amlan has raised a hand, and we'll go in the order they raised the hand. So Amlan is the first, and after that, Chaman. So Amlan, go ahead and ask questions.
Okay, yeah, thank you, Jeff. This was really very enlightening. I learned a lot. Uh, a common type of question for both will and trust. Is it a single will which works in any jurisdiction in US, like different states, or a trust? Is it a trust? It's like a legal entity which is registered somewhere, correct? So if it is registered in New Jersey, can it has property anywhere in US or the world, or every state had a separate jurisdiction? We have to register that will or trust separately.
Great question. So in most cases, these documents are not registered anywhere. They're your own private document, and they don't really see the light of day till after you're gone. So very rarely are they registered. I would say that the documents will almost always work everywhere. Different states have differences. In California and Colorado, they have community property rules, but again, may not really have a matter. Basically, the system in most states is that you have to leave a certain amount to your spouse, typically 1/3 minimum, but you have no obligation to leave anything to your children. So as long as you follow those two rules, at least 1/3 to my spouse, your will work anywhere. It's only in Louisiana and Puerto Rico, which have some of their law based on French and Spanish law, where you can't disinherit your children. But if you don't live in Puerto Rico and you don't live in Louisiana, your wills will probably work anywhere, but it's always good to have them checked out by a local lawyer, to be sure.
Great. Hey, I have a follow-up on that.
Sorry.
So if somebody creates a trust and then forgets that they created it, and later they create one more, and you said it's revocable, so does the second one override the first one?
Generally, yes. It usually says this new trust, replaces all my old trusts. So if you have that recitation, there's no problem. But if they're retitled differently, the first one could stay in effect.
Oh, okay. Yeah, Amlan, sorry, I interrupted you.
Yeah, sorry. Yeah, no, that's also good. So one more follow-up on this. So if you're saying it's really not something we registered or it sees light of the day, so is it that when the person dies, whichever, like I'm talking in a US scenario, whichever state that person was last resident, that state's law come into the play,
Yes.
even if the property might be anywhere else?
Yes. That
Okay.
state law will control.
Okay, so even if today we make a will thinking New Jersey, it's not necessary that it depends on when you pass away, correct? And the second thing, the trust, you said it has to be titled. Like my understanding is that a property is titled by some deed, correct? You do a warranty deed and you register in the county or the government office. Is that not like, how do you title your house to a trust without, if it is not seeing day of the light to anybody?
So a lot of people think just by listing the assets on Schedule A at the back of your revocable trust will work. No, you'll need a new deed. So the deed to my house went from Jeffrey and Ruth Greener to the Jeffrey Greener Revocable Trust dated, April 1st. So I had to record a new deed. Doesn't change my income taxes, my real estate taxes, my star exemption, but I had to tell the county that there's a new owner.
Okay, I see. Okay, so that is still need to be done, but it doesn't impact any mortgage or anything, correct? It's just you are transferred a general deed, correct?
Exactly. Doesn't affect your mortgage or anything.
Yeah, that happened to me because in some cases I think we had joint tenancy or something like that, which was not we were not able to put it in a trust. So we had to first change from one to another and then move that deed from us to the trust. So, hey, Chaman, I think you
So,
raised your hand, so you
so,
can go
so,
ahead.
so sorry. One last, can I just? When you like you if you are transferring a property to LLC by a deed, that LLC is a registered entity. How is the trust? Like if I say to my county that okay, I'm transferring house from Amlan to Amlan Trust, it just that's it. Like Amlan Trust doesn't need to be registered somewhere.
No, but if I have an LLC, I need an assignment of my LLC interest into my trust.
Mm.
But if you're in New
Okay.
Jersey, you come to my office in Hackensack and we will hook you up and make sure everything's done right.
Yeah, I will. I will. I'm in New Jersey. Yeah, thank you.
Okay.
I'm good, Rahul sir. Yeah.
Okay, Amlan, thank you. So, Chaman, go ahead, please.
Yeah, Jeff, thanks for the great presentation. You mentioned in your presentation that will requires validation by court, right? So does trust require any such process too, or that's a better option?
Good.
No, that's why it's generally a better option. Once I get the trust notarized and I transfer my assets into the trust, I don't need any involvement by any government agency. It's private.
So there is no executor, like we don't have to, let's say, if I die, my son doesn't have to go to some agency and say, here is the trust. Um, and
No, whoever you've named as your trustee
okay.
picks up right where you left off, either upon your disability or your death,
Okay.
with no formal, nothing formal.
Okay.
So where all these documents, the trust, they exist, physically, who owns them?
So they're your documents and you're the owner. So many times the clients will hold on to them. I would say in a safe deposit box or a fireproof box in your home. Many times the lawyers hold them. We don't charge for that. We can't keep them from a client, but we have a big fireproof vault and we hold on to a lot of them so they don't get lost. Nobody spills coffee on them. People move around. It's your document. You own them, whatever you're comfortable with. That's where they go.
Excellent.
So I was expecting, this kind of document to be saved, securely somewhere in government database as well, in case we lose the physical paper.
You would think so, but the government is way behind the private sector. And many states don't really allow for electronic anything. It's starting, Virginia, Nevada, but the courts don't want the physical copies of your wills and trusts. They don't have the room for that. So someday when, they get this whole blockchain thing figured out, will be electronic. But until now, it's all the old-fashioned way.
Yeah. I think this is important to let
So if you lost your physical document and even though you have electronic copy, it is as good as you don't have a trust.
It's a tough one. Sometimes we can prove a copy. Sometimes we can't. If you know you can't find the original and your lawyer doesn't have it, you don't have it, I would get it redone. It'll save more time and more money doing it over than relying on the copy. Sometimes we have no choice, but I would avoid it if I could.
Yeah, I think it is good to communicate to your beneficiary where the trust and will is kept. If you have kept it with your lawyer, as Jeff said, let them know where it is and information. Or if you kept it in your own home, tell them where it is, so that when you're gone, you can't communicate.
Exactly.
Seance doesn't work. So I think with that, I have a few questions. Most of my questions have actually been answered by other people's questions. So the schedule of assets that you briefly mentioned. So it is my understanding, and I was told by my lawyer that I can put all the things that I want to bequeath into the schedule of assets, and we can change it as and when we want. But what kind of things? I know home is the biggest one, jewelry, bank accounts. Do we go down to the level of like car, TV, and all these things, or computer?
Generally not. So just so you know, I think in California, you can list things on the schedule and they're deemed to be included. That doesn't work in New York and New Jersey and Connecticut. So there's a distinction. And retirement assets generally don't get retitled because they have a named beneficiary. But any bank or brokerage accounts would typically be named in the name of the trust.
Okay.
And I'm not really worried about your everyday
Yeah.
things.
Okay. Yeah, sometimes family heirlooms are fought over by people. That whatever that thing, that jewelry that grandma gave, and now I want it,
Sure.
that kind of thing. But okay, I think with that, yeah, one last question. So this is revocable trust, so which means it can be changed at later age. Now, at very old age, if our mental capacity is under question, and if we want to modify it, is that a complicated thing? Like, if a son knows that we are kind of losing it, and they contest, is that possible? Have you seen that kind of things?
I've
Not,
seen
not
just
that
about
my son
everything.
would like to ever. I just want to clarify that.
I've seen just about everything. But so in my trusts, I have the ability to not only name successors,
Mhm.
but add those people as co-trustees
Okay.
while I'm alive. If I'm losing capacity, or if they think I'm incapacitated, then they prove that I'm incapacitated.
Okay.
They will take over. That's not a pretty event, but
Yeah.
I would build those things into the documents.
Okay. Okay. And I think that's where attorneys' advice comes into picture, because these online things may or may not have thought about that. So when going to an attorney, I think paying a little bit more, they may probably bake it into the trust.
Right. Some things are not really meant for do it yourself. Not when there's so much at stake. So I would just be careful about
Yeah.
what I choose to do on my own and what I don't.
Yeah. So I think we are at the end of the questions. If anybody else has any question, please raise your hand. Otherwise, I will hand it over to Don, and after him, I will say vote of thanks. Yeah, looks like no other questions. Don, please take it away.
Okay, thank you very much. Wow, Jeff, great job.
Thank you.
Great job. Very clear, very obviously comprehensive in your expertise and sharing that with us. We appreciate it. So I would like to see if I could share a couple of slides, Raul. I'm going to try my best to do that.
Yeah.
So I'm assuming I go onto that screen again.
Yeah.
And hit present, share now.
Yeah.
And
yeah, we can see it now. We can see something.
You can see my screen.
Yeah.
Can you see what I'm sharing here?
The link to join. So we can. I think you may have more than one terminal.
Well, I think that's mine. My screen is showing.
Oh,
so how do we want to get my screen off, right?
Okay. Yeah, you can turn stop sharing, Jeff, and then Don, you can share.
All right. Let me stop sharing.
There
Okay.
you go.
There we go.
Yeah.
So now I'm going to give that a try. Sorry, folks.
No worries.
And the site will be able to see the contents of your screen. So window, I guess.
Yeah, I think
yes,
I
so
the entire screen, because that's
so
easy.
can you see that?
You have to click on the share now button at the bottom.
Okay, let's try that. So can you see my screen here?
Now I can, yes.
Okay. So let's start from the top. All right, so I just wanted to provide you again with can everybody see this? So this is my company.
Yeah.
My company is DJM Advisory Group, LLC. I am based in New York. I'm licensed in several states. Okay, these are some of the products that I do specialize in. I hope everybody can see that. So I do specialize in life insurance, and that would be term life insurance, whole life and universal life insurance. I also do long-term care insurance, disability. I specialize in annuities, fixed index especially, IRAs, 401k rollovers, and obviously Medicare Advantage plans. This is just an example. If you want to see some of the pricing, you'd be surprised how affordable it really could be to protect your family. And you can see from this matrix different examples of, let's say, $1 million of coverage. You can just go across and you can see based on this age, it's in 5-year increments. For a 10-year policy, this is all it would cost per month, provided that you're in good health. Okay. Now, what I wanted to do here was very important. If you go to this link here, and it's very easy by hitting Control, I believe, and click, that should take me perhaps to my website. Let me see if that's correct. 1 second now, folks. I apologize. Just bear with me. All right, so that doesn't seem to be working. But if you go to my website, you will see all of the products and services that I offer. There's a huge menu of resources there that you can look at in terms of what does this mean, what is this product, what does this do, how does this product work, and all the mechanics basically of different financial services products are in that website. Honestly, I believe it's one of the most comprehensive websites for financial services that I personally have ever seen. So I'm patting myself on the back a little bit for that one. So if you can go into that, it's www.djmadvisorygroup.com. There's my email address, my phone number, and I encourage you to just have a look. You'd be surprised how affordable it really is to protect your family.
Great. Thank you, Donald. And if you can email me this slideshow, I can add it into our NITRUS talks, where we post this video, then it will be available to them also.
Okay, so here it is. Can you see this screen now?
Yeah, I mean, if you can email me, I'll put it on our NITRUS talk site.
Okay, great. That would be great.
Yeah. We do that. We allow people to share how people can contact them.
Sure.
Okay, I think with that, we can conclude this talk. Let me just want to say thanks to our Subhash Indwani, sir. He's our senior. He does a lot of work. And he introduced me to Donald. And thanks, Donald, for working with me on planning this talk. And also thanks, Jeffrey, for giving such a wonderful talk. It's kind of eye-opening for a lot of people. I personally did not know about the problem of will and probate, which costs a lot of time and delay. So I created my trust and little bit peace of mind. When we are gone, we can't do anything. So we pre-plan it. So that this is a very useful talk. With that, I just want to, say thanks, and we will conclude this talk. I'll stop the recording. I remain online for some more time. If people want to talk.
Well, if I may, Jeff, did you put up your information, your contact information?
You want me to send the, Rahul, if you send me your email, I could forward you the presentation.
Yes, we can do that offline, and I'll include that on our website.
Sure, that's great. It was my pleasure.
If I may say so, I would also encourage everyone to revisit your current situation with regard to your wills, your trusts, and don't hesitate to reach out to Jeff. Jeff is a valuable resource.
Great.
Yeah, shoot me an email if you have any questions. And
excellent.
I've probably been involved with your situation. Every time I think I've seen it, something new comes up, but I'm familiar with a lot.
You bet.
And just also please be advised that we do a lot of foreign national work as well. So especially in the life insurance and annuity arena, I do have access to specialists with regard to foreign national work, folks from India. So just something to consider.
Yeah, inbound planning, outbound planning. I know India has very currency restrictions and other asset transfer restrictions, but oftentimes life insurance purchased from a U.S. company is going to be cheaper than buying it in many other countries. So we have a lot of clients who come here to buy American life insurance, put it into a U.S. trust, and keep it out of the confiscatory tax schemes of their home countries.
Yeah, and I think you seem to know a lot about India, because I wasn't even aware of those 3 types of wills. So you must have worked with a lot of South Asian clients. So yeah, that's great. I think I'll stop the recording and we can continue chit-chatting after this, but I'm stopping the recording right now.
Okay, my pleasure.